Inside the Royal Courts of Justice and across England and Wales, the single family court operates as the centralized national venue for domestic family law. When an application is made, it enters the system through a centralized gatekeeping team. This team provides the initial processing for every incoming case, from high court judges to lay magistrates. For example, financial provision proceedings follow a standardized route directly to a district judge. This highly engineered domestic machine operates under the overriding objective of Family Procedure Rules Part 1 to deal with cases justly, efficiently, and proportionately. But the efficiency of this domestic system relies entirely on shared legal frameworks. When a case involves parties in different countries, the rules of allocation abruptly change. To function efficiently across borders, the single-family court requires seamless international treaties. Without them, the domestic machinery stalls. This map shows the pre-2021 jurisdictional baseline. For years, the UK operated within the EU's Brussels II bis regime, providing a unified system of interstate cooperation. It allowed for automated recognition of divorces, unified jurisdiction rules, and streamlined enforcement of maintenance orders across borders. The British government ultimately chose to leave matters of family justice outside of its Brexit negotiations, implementing the European Union Withdrawal Agreement Act 2020. As the UK officially exited the regime, those unified reciprocal legal pathways shattered. A narrow transitional exception remains in place. Any family law proceedings formally issued in the UK or an EU member state before 11 p.m. on December 31, 2020, continue under the old Brussels II bis rules. For every case issued after that deadline, the automated EU framework is gone. The UK and its European neighbors now default to a complex patchwork of existing private international law. The dismantling of this unified system has replaced a streamlined procedural step with a highly contested legal battleground. To fill the void left by Brussels II, the UK must rely on its status as a signatory to several older international Hague conventions. This comparative matrix maps out the new fallback treaties. For matters of international child abduction, proceedings are now routed through the 1980 and 1996 Hague Conventions. For international financial support, child maintenance enforcement connects directly to the 2007 Hague Convention. While these treaties provide a legal mechanism for inter-country cooperation, they are not a one-to-one replacement for the EU regime. Look specifically at the 1996 Hague Convention. When applied in practice, severe structural gaps immediately emerge. First, unlike the previous system, there is no automatic enforcement for contact orders. Securing rights of access across borders now requires lengthier manual legal action in the foreign court. Second, under the 1996 Convention, if a child's habitual residence changes during a case, the local court automatically loses jurisdiction. If a divorce has finished, parents can no longer simply agree to let the original court finish finalizing their child arrangements. Relying on these standalone treaties introduces severe procedural friction. Crucially, the home country has lost the ability to smoothly override decisions or manage linked proceedings across borders. Because the UK has not yet secured accession to the unifying Lugano Convention, courts face a jurisdictional vacuum. To resolve it, they revert to a common law doctrine known as forum non conveniens. The core objective of this doctrine is to determine the proper place, or the most appropriate forum, to hear a dispute when multiple countries might have a claim. This radar chart visualizes the closest connection test, the specific mechanism a UK judge uses to weigh where a case belongs. The court must evaluate hard variables, plotting the client's nationality, physical residence, legal domicile, and the exact location of their financial assets. But it must also weigh softer variables, the viability of the proposed alternative court, where the children attend school, primary languages spoken, and the family's cultural background. Under Brussels II, jurisdiction was dictated by rigid, sequential rules. Under the closest connection test, jurisdiction is entirely subjective. As the specific facts of a case alter the balance of the chart, the legal gravity pulls jurisdiction toward or away from the UK courts. Establishing jurisdiction is no longer an objective checklist. It is a highly subjective, multivariable argument that lawyers must win before the actual case even begins. This Gantt chart represents a standard cross-border legal timeline. In the pre-2020 state, determining jurisdiction was a fraction of the total process. In the post-2020 state, the preliminary jurisdiction phase expands massively, delaying the start of any substantive proceedings. Because the closest connection test requires hours of subjective arguments over domicile, assets, and language, we can see the direct financial impact on the client. As the timeline expands to accommodate jurisdictional arguments, litigation costs spike exponentially. This procedural barrier traps Anleys. While lawyers argue over which country has the right to hear the case, the actual disputes regarding children and finances remain entirely unresolved. The friction of simply deciding where to hold a trial now prices many individuals out of accessing international legal remedies entirely. Even if a client affords the delay, wins the jurisdictional argument, and secures a final UK judgment, they face one final hurdle: enforcing that order inside an EU member state. Without reciprocal EU treaties, a finalized UK judgment hits a strict national law checkpoint. The recognition of a UK divorce or civil partnership dissolution now depends entirely on the specific individual laws of the target country. In domestic abuse cases, the UK has promised to recognize incoming protective orders from the EU, but the EU has not reciprocated that policy for orders originating in England and Wales. This creates a severe operational risk. UK judgments can be legally declined by foreign courts, forcing the client to completely relitigate the entire matter abroad. For family law practitioners, this forces an emphasis on exhaustive preliminary investigation before the first application is even filed. To navigate the post-2020 single-family court, practitioners must meticulously front-load their international cases, preparing for intense, costly jurisdictional battles before a single